This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about why no court has unlimited patience and failure to plead a viable complaint after 4 trials stops everything. Scott Manley moved the United States District Court to dismiss 2 claims plaintiff Mark Esquibel asserted against him in the Third Amended Complaint for wrongful termination in violation of public policy, called a Tameney claim, and for promissory fraud. Because Manley was Esquibel's manager at Kinder Morgan, not his employer, Manley cannot be liable for the Tameney claim as a matter of law. For the same reason, Manley contends that he cannot be liable for promissory fraud resulting from alleged assurances in or around 2008 that Kinder Morgan would provide Esquibel with insurance coverage during his employment. More problematic, according to the trial court, is that these alleged assurances occurred in 2008, but Manley did not become plaintiff supervisor until 2017. In Mark Esquibel v. Kinder Morgan, Inc. et al., the United States District Court for the Northern District of California on October 17, 2023, explained why its patience had been exhausted. Esquibel asked for leave to amend to assert totally new claims against Manley, including eavesdropping in violation of the California Penal Code, Section 632, and invasion of privacy harassment under California's Fair Employment and Housing Act, and claims for intentional and negligent infliction of emotional distress based on the alleged eavesdropping and harassment. Esquibel did not address the standard for granting leave to amend or explain why, despite the multiple opportunities to amend he was given, he failed to allege these claims in any of his prior 4 complaints. The claims that he sought to add new based on eavesdropping in violation of the California Penal Code and systematic harassment and intimidation based on use of racial slurs rely on factual allegations that were made in this case at its inception. In the trial judge's June 2023 order, Esquibel was given one last chance to amend. In that order, the court explained to Esquibel that facts were missing, but were necessary in order to state viable claims. He then filed the amended complaint only to find it denied, and Kinder Morgan's third motion to dismiss, allowing the Tameney claim and the promissory fraud claim to proceed. Given the multiple opportunities Esquibel has had to amend, the one last chance warning given, and the significant prejudice caused not only Manley but Kinder Morgan, who repeatedly and successfully moved to dismiss, resulting in the court's narrowing of their chances left at issue, by Esquibel's dilatory tactics and attempts to plead yet more claims based on facts known since the inception of this litigation, further leave to amend was denied. There is simply no excuse for Esquibel sitting on these claims. There has been undue delay and dilatory conduct causing significant prejudice to the defendants. Esquibel's piecemeal approach to his pleadings and seeming inability or unwillingness to fully plead his claims despite the court's orders, and defendants pointing out the multiple deficiencies in his claims, is unacceptable. Construing his opposition to the motion to dismiss as a properly noticed motion for leave to file a Fourth Amended Complaint with wholly new claims against Manley and logically against Kinder Morgan, The motion was denied. Defendant Manley's motion to dismiss was granted, and the litigation stopped. In my opinion, some judges have the patience of Job with litigants and allow them multiple opportunities to find a way to plead a viable cause of action. The judge in this case gave the plaintiff 3 tries and warned Esquibel that the last order was his last chance. Ignoring the warning, Esquibel tried a new way to allege a case that had nothing to do with his first 3 tries. His failure ended the court's patience, and the order was dismissed. Why the court did not sanction Esquibel under Rule 11 is difficult to understand. Courts need to control their calendar and not be so patient. And the defendants might have a viable malicious prosecution action against Esquibel if he has enough money to pay them. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. If you found this video and or the blog to be useful, please click on the like button, subscribe to the blog, and get access to every blog posting, usually 5 or 6 a week, and the 4,600 more blog postings will be available to you. You can also subscribe to the videos on YouTube and on rumble.com, all of which are free. And if you do, I'd appreciate it if you click on the like button or the thumbs up button on rumble.com. And if you're interested in more detailed information about insurance, insurance law, insurance claims, and insurance fraud, please consider, for a very small fee, subscribing to my Substack publications or my locals community. Thank you for your attention.